associate editor of the Clover Arbitration blog.
Is it just me or everybody lost Prakhar?
Associate editor of the Clover Arbitration blog.
I think we kind of lost him, unfortunately.
I think there's a internet glitch.
Sorry, there's a glitch with the internet. Actually, sorry for the interruption, Dr. Zivkovic. I was introducing you. So yeah, before joining the University of Aberdeen, Dr. Zivkovic held the position of an assistant professor at the International University of Sarajevo, where she coordinated and taught civil law courses. There's a lot on the internet about Dr. Zivkovic and her works and her research interests. I would rather request Dr. Zivkovic to tell us something about herself, which probably the internet and Google does not know about her. Over to you, Dr. Zivkovic.
Thank you, Prakhar. Thank you for this lovely introduction. I doubt that that people don't need to Google me, but thank you for saying that. It feels really good.
You're not audible.
Yes. I think you are now on two screens, so I can hear you and see you on two screens.
Yep.
There is an echo. If you could mute both of your devices, that'd be great. So I think you covered it rather well. So I come from, my background is in private international law and international commercial arbitration. The topic today that I'm going to present is actually the topic that I wrote my PhD on, and that now I'm working on converting into a monograph. However, I have one other area of research and teaching, and that's data protection, with a specific focus on artificial intelligence and biometric data, which I developed through my the interest that I developed through my practice a few years ago. But today I'm going to be really in my comfort zone. And before I begin, I want to thank you and Vasik and the rest of the organizing committee for inviting me to this very first lecture, guest lecture organized by your university. I had no hesitation in accepting this invitation, and I'm very excited to talk about the topic that I am very passionate about. So I'll share the screen now because I prepared the presentation. Can you see my presentation? Let me just do it again because I want to share it as a, I think it's gonna work now. Okay, can you just confirm?
Yeah, it's visible.
Okay. Cool. I'm starting the slideshow. So the topic of today's lecture for the next hour and a half, and then I would very much like to hear any comments that the audience might have or any questions, because it will also really help me with my preparation of the manuscript. So the topic is cost claims in international commercial arbitration. It's quite wordy, the whole title, Understanding Theory Today for More Efficient Practice Tomorrow. For those who are active in the field of international commercial arbitration, we all know how important it is to understand the theory, and mainly due to under-regulation or lack of regulation in international commercial arbitration, although that is changing in the past few decades. So what I'm trying to do with my topic of the monograph, I'm trying to look at the underdeveloped theoretical concepts when it comes to costs, which would help with making the whole proceeding more efficient and bring back the legitimacy to arbitration. What I'm planning to do today, I was told that this talk might be attended or will be mainly attended by students. So I'm going to give a very short introduction of the fundamentals of international commercial arbitration. Those who are active in this field, please bear with me. It's going to be rather short. Then what I'm going to talk about the definition and importance of cost claims in arbitration. And then I'm going to proceed with specific theoretical issues that deal with the determination and payment of costs, impecuniosity of a party in arbitration, and the standard for the allocation of costs. So at the end of this lecture, I hope you will get a clear picture. First of all, why am I writing a whole book on such a practical topic? Because for me, it is not practical at all. It's rather theoretical because of the lack of regulation. And hopefully you will get an overview of what are the important notions that we need to think of when we enter arbitration in practice when it comes to the costs. So just a short introduction of the fundamentals, as I promised. Those who are students and who had no course on arbitration, and they had, or if they're LLM students, as well, if you're not focusing on commercial law, this might not be something that you have heard of before or not in such detail. However, arbitration in a nutshell is a private, non-judicial process for the settlement of disputes. So it is an alternative that has become mainstream in the past 60, 70 years to commercial litigation. What I'm going to focus on today is international commercial arbitration, which means I'm going to focus on arbitration that is between two commercial entities. So dispute resolution between two commercial entities, and those disputes have an international element, which is usually means that the parties are not from the same state, so they have places of business in different states. As I said, today arbitration is considered one of the mainstream dispute resolution methods for commercial disputes. And just to give you an idea what this looks like when it comes to dispute resolution, so that you understand, for those who haven't had any classes on it, a dispute resolution method continuum is rather broad. So it is not the decision that is made between arbitration and litigation. There are many non-adjudicative dispute resolution methods that are equally effective in commercial disputes. However, arbitration is definitely taking #1 place at the moment. And that is confirmed also in the latest surveys. For example, the one conducted by Queen Mary University and White & Case law firm. They are conducting surveys every year or every second year of different aspects of arbitration, and this one is from 2021. So you can see that majority of respondents to the survey would prefer arbitration with ADR or international arbitration only as a method of dispute resolution. So just to give you some context, why is it so important to talk about arbitration and commercial arbitration if you haven't been involved in any research? Two things also that I would like to use in the introduction, because they are crucial to understanding other issues that I'm going to talk about, is distinction between two main types of disputes and also legal sources hierarchy in arbitration. So when it comes to arbitration, we often say that in commercial arbitration, we have two types of disputes. Whether that's right or wrong way of framing it, it's a entirely different question. But the main distinction is that in ad hoc arbitration, you will not have administering institution, whereas in institutional arbitration, you will have a fourth party, as I'm going to show in a tetrapartite agreement that is basically administering the whole proceedings. The usual way that the parties choose institutional arbitration is by choosing the institutional rules. The reason why I'm so skeptical whether these are so different or not is because it doesn't mean that ad hoc arbitration has no rules. Often it does have rules, it's ancestral arbitration rules. However, it definitely does not have a body that is dealing with the administration of the process. In majority of cases, it is the presiding arbitrator who takes the role of the administrator, main administrator of the proceedings. This is important because we will see how this impacts the determination of costs in international commercial arbitration. And finally, the final point of my short introduction is what is the legal framework of arbitration? So what's the hierarchy of the legal sources? And it's important in that case, these are just some of the important international rules and conventions that are applicable and that I'm going to mention today. However, this is the picture that those who had no course on arbitration, I would like you to take with you for the rest of this lecture. So the main basis or the ground for establishing an arbitral tribunal's jurisdiction is so-called arbitration agreement. The arbitration agreement is concluded between two parties, either for the current dispute or for those disputes that might arise from their contractual relationship, for example, in the future. Without the arbitration agreement, there is no international commercial arbitration. That's the minimum that has to happen for the jurisdiction of the arbitral tribunal to be established. Now, I said at the beginning that arbitration is a substitute or it's an alternative to litigation. And to some extent, it functions as a judicial dispute resolution method, but not entirely. So the whole role of arbitrators, whether it's private or whether it is judicial or quasi-judicial, whatever we would like to call it, can be a topic, and it was a topic for different monographs on that. The main thing that I want you to remember is that in arbitration, after the arbitration agreement, the next most important legal source are arbitration rules. And these are institutional rules. Institutions all over the world publish arbitration rules. They are non-governmental, usually non-governmental, or they're quasi-governmental bodies that develop know-how or the best practices how to resolve disputes. One of the most I can even say popular or prominent institution is the ICC in Paris in France, where we have the headquarters, but that institution also has branches in different jurisdictions as well. But every jurisdiction, or almost every jurisdiction, will have a national institution. Being a national institution for arbitration disputes does not mean that you deal only with the domestic disputes. You also deal with international disputes. They are called nationals mainly because of the seat, but they should be completely independent from the government. So arbitration rules are basically an extension of the arbitration agreement, and they determine how to conduct the proceedings in a much more detailed way. Then we have national laws. National laws, except for those mandatory rules of the arbitration acts, apply only if there are no solutions in the arbitration rules or if the parties have not provided otherwise in their arbitration agreement. So those three legal sources, as you can see, are already different, or the way they function is already different from what we are used to in litigation, where, of course, the first and foremost thing that we look at are national laws and then constitution. International treaties can be about that in some jurisdictions, depending on the hierarchy of sources, whereas in arbitration, we start with the arbitration agreement, arbitration rules, and then we go to national laws. This will be important when I'm going to talk about the determination and payment of costs. So this is the most important, the overview or the fundamentals of arbitration for those who have not studied it before, that I would like you to take with you throughout my presentation. Now, why did I even decide to write about costs? And I wrote about them. So my research took place from 2012 to 2016. And then I did a lot of practical work in relation to cost claims and many writings for practitioners. So for example, if those who are very much in the arbitration field, you're using the Kluwer database, you will see that in Practical Insights, I authored 2 practical insights, one on the determination and payment and one on the allocation of costs. So in the meantime, since 2016 till today, 2023, I have focused on different theoretical concepts and published different articles and have not gone into writing a monograph right away. However, it became quite clear to me a year ago that nothing was persuasively published. Nothing that was published was persuasive enough to cover everything I covered in my PhD. And that's when I decided to seek a contract with Elgar, and I got it. And now I'm converting this into a monograph. So we are still, it's quite disappointing, especially having in mind how much we discuss costs and efficiency, that there is nothing published at the moment that can be persuasively used for theoretical understanding. Now, why? First of all, I'm going to talk about the definition, but also about the importance of costs. So when we talk about costs in international commercial arbitration, probably what first comes to mind is arbitrators' fees. And then also, if you're institutional arbitration, you have to pay administrative charges. Definitely, you would be concerned with the representative fees, so how much you're going to pay for your representation to your attorneys. What is interesting, and I think that has not changed since I last checked, is that even though we are focused so much on the arbitrators' fees, the attorney's fees or the fees, costs of representation, are the biggest part of the cost pie chart. So they are up to 80% or even higher today. So something, food for thought to think about how often we focus on something that is less relevant instead of changing a bigger problem. Now, when it comes to definition of cost, there is no uniform definition of cost because it will depend usually on the arbitration rules that you have agreed on, or national laws if you are in ad hoc setting and you have not chosen ancestral arbitration rules to apply. So you will have phrases such as costs of the proceedings, costs of the arbitration proceedings, and so on. I've decided to use costs of arbitration for everything that is paid as an expense or cost in international commercial arbitration. I divide them to procedural costs. So what do you pay as a party for the arbitration proceedings to function, to move forward? And that includes fees and expenses of the arbitral tribunal and institutional fees. And you have party costs, which is basically the cost of representation, which does not always need to be just attorney fees. It can be in-house counsel's time that was spent on, if it's quantifiable as well, and other expenses such as experts or translation costs, travel costs, and so on. Institutional fees are paid, and they are in different color on this slide because they're paid only when we have, of course, the institutional arbitration in question. And 2 types of fees. Filing fee is something that you pay when you submit your statement of claim. and administrative fee is usually paid as part of the advance on cost that I'm going to talk quite a lot about, which covers the expenses of the administration of the whole proceeding. So even to just commence and submit your statement of claim, you have to pay so-called filing fee or registration fee. Why is it so important to understand them? Finally, 20 minutes into my talk, but I think if you are working in this field in the past decade or two, there is no way that you have not participated in at least one talk or one conference or even multiple conferences where efficiency of arbitral proceedings was discussed. Time and cost management. What should we choose? Should we choose the quality or should we choose time and cost efficiency, and that famous triangle between the quality, time and cost, and so on, and how you can only choose basically two. So the respondents to different surveys also in the past 2 or 3 decades are being more and more concerned that arbitration is becoming more expensive. And given that arbitration was developed as an alternative to litigation, and now it's becoming equally expensive or even more expensive, it's becoming a concern. Also, surveys are often listing lack of effective sanctions or lack of insight into arbitrators' efficiency, lack of speed as the main disadvantages of arbitration. And I hope that my presentation today will show you how often we have delays because we don't understand this particular procedural aspect of arbitration proceedings in relation to cost. There are others, but I'm not going to focus on them. I'm just going to focus on cost claims. When discussing the influence of the anticipated cost allocation, the authors in literature more and more are talking about means to sanction parties' behavior. To what extent? First of all, I wrote an article on it. I wonder to what extent it is efficient, given that it comes at the end, and given that you don't often have this means to sanction the party if the party is the winning one. And I'm going to talk about that when we talk about allocation of costs. The importance is also that arbitrators, unlike national judges and institutions, are entirely funded by the parties in arbitration. And one small part of my talk today will deal with what happens if you can't pay them and you lose access to your chosen forum, whether you retrieve your right to go back to national courts or you don't. What do we do in that case? Can we deprive a party, impecunious party, completely of access to justice? That again is connected with the claim, or as I'm going to prove, that arbitration even cannot commence without the payment of costs in advance. And generally there is lack of regulation and theoretical work on cost claims and their contractual grounds, which can result in prolonged proceedings or denial of justice. So before I move to the very first stage that I will discuss, which is determination and payment of costs, I just want to clarify, when I say cost claims or cost-related claims in international commercial arbitration, I'm not thinking of only the claim or request for allocation for the reimbursement of costs at the end of the proceeding. That is something that is quite well known, and it's a common misconception to focus only on those cost claims. Throughout the proceedings, there are multiple stages where certain claims and requests can be made. And when they're made and there is no theoretical background, or there is no regulation on the matter, that's when we get into the procedural delay. And that's what I'm going to show in this talk. So there is claim request for payment that happens quite early in the proceedings. Then there is a claim or request for reimbursement of the paid share of the advance. I'm going to explain how the advance is paid, and then what happens if one of the parties does not pay it. Claim request for reduction in arbitrators or institutions' fees, dispute over the amount of fees for arbitrators and related claims, and then finally, we have claims request for the reimbursement of costs at the end of the proceeding. I will not be in a position to go as deep in every single one of them, but I hope I'm going to illustrate how these disputes or how these claims and requests can be problematic in practical terms. And before I continue, I'm going to take a short break and sip some water. Right. When we talk about determination and payment of costs in international commercial arbitration, as I mentioned earlier, this is something that happens quite early in the process. First of all, if you are in the institutional arbitration, if you had chosen the institutional arbitration, you will have to pay the filing fee, and then the institution or the tribunal will determine so-called advance on cost that I'm going to talk about. If you're in ad hoc setting, we have to take a look at who is to determine that advance or the costs, including fees and expenses of the tribunal, and who owes to pay it and at which point. Now, that is something that is usually not regulated in detail. We have some national laws, or majority of national laws will say something along the lines that parties are due to pay the advance on costs. However, what is the basis of arbitrators claiming such a payment is a completely different matter. So on this slide, what I'm trying to depict is basically the formation of so-called tripartite agreement. So we know that the arbitration starts or the jurisdiction is established by the parties in dispute, either concluding the arbitration agreement in advance or once the dispute has arisen. And then once they nominate an arbitrator or appoint an arbitrator, such arbitrator accepts the nomination, we can say that a so-called tripartite agreement is concluded. There is almost nothing in regulation when it comes to this type of the agreement. There is some theoretical work, there is some jurisprudence on it. Some authors have written persuasively on this type of the agreement, and also the agreement between the arbitrator and the institution. However, when it comes to the formation and what types of duties and rights are coming out of this agreement, we can't find anything in national laws. So we are naturally confronted with the question, okay, so if we have this agreement, and we know we do, what does it consist of? What are the duties and obligations? So definitely one duty is for the arbitrator to provide a so-called service of delivering justice or resolving the dispute in a particular case. The right of the arbitrator is to be paid for the service that they're delivering. This is in no way me concluding that this is an agreement on provision of services. I'm not saying that. I just don't have a better word to call what they are doing at the moment. So at the same time, parties owe the arbitrator to pay a certain amount of fees. And then the question is, how do we know which amount they are to pay? And where does that negotiation of fees happen? Well, it happens between arbitrator and both parties. I'm going to talk about what happens if it's negotiated with one party. So naturally, and I'm going to talk about this issue later on, the question is, to what extent are all parties involved free in these type of negotiations? And what happens if one party disagrees with the amount? What happens if the arbitrator disagrees with the amount? What happens If the arbitrator agrees with the amount and continues to arbitrate, but knows that one of the parties did not want to pay the higher amount that they requested. So a lot of issues can arise. Among them is also whether arbitrators can decide on their own on the amount of fees when they're allocating the costs, and deliver basically judgment in their own or decision in their own matter. I'm going to touch upon those theoretical questions. When we have an institution, you would think that the situation will be easier, and it is to some extent. So when we have an institutional arbitration, I like to call this agreement on cost so-called tetrapartite agreement, just to reflect that there are 4 parties involved that need to agree to a certain rule on the determination of costs, payment of costs, and cost schedule. So I'm not claiming that there is a contract. I think that these are all separate contractual obligations between the parties. However, when it comes to the agreement or the understanding, all 4 parties need to agree on a particular cost schedules and rules on the determination and payment of costs. And that's contained in every single arbitration rules provided by the institution. So what does that look like? For example, you will have ICC rules in Appendix 3. These rules are accepting, or they're adopting the approach that the fees of the institution and arbitrators are dependent on the amount in dispute. So ad valorem method, basically. Common law approach, especially the one of the good example is LCIA, so London Court of International Arbitration, usually applies hourly fees that are calculated and estimated in advance. So this is just one example of the cost schedule that the parties, by concluding the arbitration agreement, choosing the arbitration rules, which means that they're accepting the institution to administer under those rules their proceedings, and then appointing the arbitrator, they also implement this particular cost schedule in their agreement, and all 4 parties are aware of it. You will notice that there is, between for arbitrators' fees, there is a certain discretion. Usually, and I'm not going to go in details because it depends from rules to rules, who is to determine the amount. Usually it's the institution, sometimes it's the tribunal, although my research at the moment shows that that has become an exception. So even those institutions that 7 years ago would allow the tribunal to determine the amount now have abandoned that practice. So even when it comes to arbitrators' fees, you will notice that there is a minimum and maximum, which means that the institution has a full discretion under the rules to decide between those 2 amounts. Again, an interesting question that I will pose is, to what extent is that decision challengeable for the parties? Then let me dive into the theoretical question. So as I mentioned, if we have a tripartite agreement, one of the questions will be, to what extent can arbitrator impose an amount on the parties, whether they can decide by themselves what the fees will be. One would think that this is a simple question, and it is to some extent, because there is a general agreement that arbitrators cannot decide in their own matter. However, how do we get to that conclusion is a completely different discussion. So you will have jurisdictions such as Germany and France that will be very strict in stating that decisions that arbitrators render on their amount of fees without both parties' consent are considered against public policy and unenforceable. However, there will also be a group of jurisdictions that will say, well, we don't really need to claim that they're against public policy because they can't enforce it. Now, on which ground that decision cannot be then enforced, that depends from a jurisdiction to jurisdiction. But it took some time for these opinions, and they're not formulated in all jurisdictions. So you might face in your home jurisdiction a question whether arbitrators, by simply putting a certain amount in the final award stating that that's what they're owned, whether that can be enforceable. Swedish Arbitration Act has a very simple, not simple solution, but the most direct solution I have seen in the regulation of this issue. So they say that the parties may order to pay compensation to them in the final, that the arbitrators may order the parties in the final award to pay certain compensation on them. However, at the same time, another section of the Swedish Arbitration Act will allow a party to contest that amount. So they are dealing with this question quite practically, which I have not seen in many other or in any other regulation, Arbitration Act, national legislation on arbitration, which means that they have this construction of consent in a sense that if a party in dispute does not object, does not bring an action to a district court, then it's going to be basically enforceable against them, because there is a deadline within 3 months from the date upon which the party have received the award. To what extent it is fair to expect the parties to bring yet another action and have another dispute against the person that decided their case, it's a completely different discussion that I'm discussing in my monograph. Another interesting question is, and I already offered an answer, but once again, this is not regulated. This is developed mainly in the English arbitration practice. And I have some reservations about it because of the regulation of impartiality in the English jurisprudence. As you probably know, the Halliburton case brought some clarity on it, but the English Arbitration Act is one of the few that talks only about impartiality and not independence. So it becomes a bit blurred whether it's applicable to other jurisdictions. But one thing is for sure, that there are at least a few decisions that made clear that in practice, the fee arrangement between the arbitrator and the parties needs to be consented to by both parties. So arbitrators cannot unilaterally impose the amount, and at the same time, they cannot agree on the amount only with one of the parties, because that would impair their impartiality. An interesting question is, to what extent can, even if the arbitrator backs down and continues with arbitration, to what extent would refusal by one of the parties to pay a higher fee impact their impartiality and independence? That's also something that is interesting to think about. So as I said, there are a few cases, and for example, in it is confirmed that it's wrong. It's basically considered to be a misconduct to agree to accept a fee from one party after the start of the arbitration, not from the other. So it is something that the English jurisdiction has confirmed, but I have not found that many confirmation in other jurisdictions, although it seems the proper way forward. Again, not regulated in the contract law or in arbitration acts. So the question that remains is if in ad hoc decision, but in ad hoc arbitration, but also in institutional arbitration, the parties do not agree with the amount of the fees that are determined either for institution or for arbitrators. What can they do? Again, something arbitration acts do not regulate. However, I see two ways of moving forward that have been shown confirmed in the practice as well. One is the challenge of the decision on costs in the ordinary course before the national courts. So when you, for example, have an ad hoc arbitration where the arbitral tribunal is deciding on their fees and expenses throughout the proceedings, there should be a ground for one of the parties or both parties to insist on setting or adjusting the fees of the tribunal. The only arbitration act that has that as it stands now is the English Arbitration Act that provides specifically for national courts power to do this in the arbitration, during the arbitration proceedings. There is another aspect also distinguished under the English Arbitration Act, where national courts have power to decide on the recoverability of the costs. That is something that can bound arbitrators when they allocate the costs at the end. So it's not specifically related to determination, but there should be an option or a ground for challenging the decision on costs in the ordinary course before the national courts, which means that this would be a challenge that happens before rendering the final award. On the other hand, actually, is the challenge of the decision on costs in the proceedings for setting aside of the award before national courts. This could be indirect challenge of the decision on costs or direct challenge of the decision on costs. So every award will contain a separate decision on the allocation of costs. Now, sometimes you can have a separate award on costs, especially in those cases where the costs are so high that they basically require special deliberation among the tribunal how to allocate them. So as long as your challenge is aiming the provision or the statement on the allocation of costs or the separate award on costs, that is called direct challenge of the decision on costs. And one of the options or one of the grounds on which they can be challenged is basically the public policy or conducting proceedings not in agreement with the parties and so on. Indirect challenge of the decision on costs happens when the parties challenge the whole final award, either fully or partially, and then basically the decision on costs, if there is any such, if the challenge of the award is positive, if it is proven, then the decision on cost should also follow the destiny of the final award. So it's not really attacking the decision on cost, but indirectly you are quashing this decision as well. As I said, some of the national arbitration acts have specific norms, provisions on how to challenge the decision on costs, such as English Arbitration Act and the Swedish Arbitration Act. My hope is in the future that this will become the standard provision in other disputes, in other jurisdictions as well. So that would be it on the determination of costs. Now, moving to the second part is the payment of the advance on cost, something I have already mentioned. So basically, in my introduction and while talking about the determination of cost. So why does the determination of cost come into play at the beginning of the proceedings? It is because the arbitration proceedings are funded in advance, which means that at the beginning, and I'm showing on this slide the ICC rules example on how this is done. In the institutional arbitration, for example, under the ICC court will fix the advance on cost. So basically, this advance is a deposit that will sit usually with the institution or with the presiding arbitrator in a special account and so on, that will be a security for the cost to be paid to arbitrators and the institution for administering and deciding in the matter. The importance of this fact is, of course, what happens if these costs are not paid. And this is something I'm going to talk next. But before I do that, just a few practical observations. So the advance usually includes the fees and expenses of the arbitrators predicted based on the cost schedule, the ICC administrative expenses, and any other expenses incurred by the institution related to the arbitration. If the advance, which I said functions as a deposit, is not completely exhausted, in that case, the remaining money will go back to the parties. Who pays the advance? Under almost all institutional rules that I've read, this amount is to be paid by both claimant and respondent in equal amounts. So we could say theoretically that by accepting certain rules, the parties are implementing this obligation to pay in equal amounts the advance on costs. In some cases, there can be separate advances for claimant and respondent if we have counterclaims, because especially if the amount in dispute is so high on both sides that it's not fair for the claimant to bear all the costs in case the respondent fails to pay. And that's something I'm going to talk about next. So if everything goes smoothly and the institution or the arbitrators determine the advance, the parties are happy with the amount, they both pay in equal shares, and we can proceed with the main matter, which is the resolution of the dispute. That's a good day in arbitration. However, what happens more often than not is that one of the parties, usually the respondent, fails to pay their share of the advance on costs. And then in this particular diagram, I'm trying to show that by agreeing to certain institutional rules, we are creating entitlement for arbitrators or institution to request the advance on cost. We are creating the obligation to pay the advance on costs by party A, party B, to the institution or the arbitrators. But the question is, if one of the parties fails, to pay, what can happen next? Because as I said, usually the procedural consequence of this non-payment is that the arbitration will not continue. The arbitration rules usually resolve this matter by specifically saying that if the respondent or if any of the parties fails to pay their share of the advance, the paying party, the one that already basically paid what they owe to the institution or the arbitrators, can cover the other half of the advance. In practice, what happens, claimant submits the statement of claim, the advance on cost is determined. The parties that agreed to arbitrate are invited to pay the advance in equal shares, and respondent fails to pay and claimant covers all the advance. Now, this does not mean, of course, that by the end of the proceedings, this will be completely paid by the claimant. The claimant can claim, of course, reimbursement at the end through the allocation of costs from the arbitral tribunal. And that is what usually happens, because the claimant, as the most interested party in the dispute, is usually, not usually, let me strike that out, but it's probably someone who has the interest and most likely will be the winning party. So they will claim the reimbursement of costs at the end. However, the question that was posed in practice by those claimants that did not want to wait for the end of the proceedings to claim this substitute payment, mainly because such a substitute payment can be quite high. So they didn't want to wait until the end of the proceedings, a few years, to claim the reimbursement. They requested the immediate reimbursement during the proceedings. And this is something that usually then evolves into a satellite dispute, because it is not clear in most jurisdictions whether this is a contractual claim, whether it is only procedural, or whether it's an interim measure ground. So different approaches have developed in different jurisdictions in terms of whether usually claimants in that case have the right to request immediate reimbursement, which means that at the beginning of the proceedings, not only that they are proceeding with the main matter, subject matter of arbitration, but they also claim that the respondent needs to pay their half back to them. Now, what happens in this case? As I said, 3 approaches developed. I'm not going to go in detail, but I'm going to give you some basis, and hopefully you will understand the complexity of the matter. So the contractual approach is the prevailing perspective, under which it is considered that in this particular case, this obligation to pay the advance on costs is not owed only to the institution, but it's actually an obligation between the parties, which means that if one of the parties pays the full advance, the other party should reimburse them immediately, or at least not to reimburse them, but there is a contractual ground for such a claim. The procedural duty approach says that basically the obligation to pay the advance is only owed to the institution. And very similarly, the interim measure approach says the same. And that basically the only consequence we can have is the procedural consequence, which means that the proceedings will not continue in case of one of the parties does not pay. In other words, this approach states that there is no obligation between the parties to pay this in equal shares. It's just something that is owed to the institution, and the party that paid the whole advance needs to wait until the end. So in practice, this is something that is not resolved in all jurisdictions. There are these different approaches. I am advocating the contractual approach. However, at the same time, I'm quite sure that in any case, this would involve a discussion and a satellite dispute that needs to be resolved on the other side. So hopefully we can move into more regulation on this point as well, just to provide some clarity in this tripartite agreement, whether we have grounds for contractual claim or not. Next topic I'm going to deal with asks a different question. Note if if respondent in this particular case is usually the non-paying party, not what happens if respondent refuses to pay or cannot pay, but the question is, what if the claimant cannot pay? In that case, we have a question whether we can even file the claim, and then even if they cover their part of the advance, whether we can expect them to cover the remaining part of the advance that the respondent did not pay, and what happens if they don't have the money to do that. So that's the topic of impecuniosity of a party and access to justice. That being said, another sip of water. I haven't had this long lecture in a while, since pre-COVID. Okay, so what is impecuniosity? Impecuniosity might overlap with bankruptcy, but it does not need to. Now, I'm not going to deal with bankruptcy because bankruptcy involves certain status considerations, and I wrote also on that, and then we have the clash between two regulations or two laws, arbitration law and bankruptcy, and it becomes a bit different story what happens with the contested claims in arbitration and so on. That's actually an area in which we can find some direction and guidance as to what is one to do when it comes to contested claims in arbitration. But when it comes to impecuniosity, I'm talking about basically financial incapacity to pay the share of the separate advance on costs or to pay legal fees. So the party is not bankrupt, but it's basically financially not capable to cover the costs. So what happens then, as we know by now, is procedural consequences of the withdrawal of the claims and termination of proceedings. Now, usual circumstances of such a case is that substitute payment is not an obligation. So if the claimant, remember when I talked about this, the obligation is to pay the advance in equal shares, but the obligation is not to cover the other side's part of the advance on costs. Claimants do it voluntarily under the institutional rules because they want to proceed with the proceedings. However, respondents might not have the same motivation, and rarely commercial parties act in an altruistic way. Legal aid is not guaranteed. There is a possibility of third-party funding, which will depend, for those who are very much involved in that, will depend on the success of the claimant in the case. So third-party funders are not blindly accepting funding in any particular case. They will very much do due diligence, and they will assess whether there is a possibility of success for the claimant. So it's not guaranteed in that sense as well. Neither of the parties was economically weak when the agreement was concluded. This is important because of the creation of expectations at the moment of the conclusion of the arbitration agreement, and we assume arbitration agreement is valid and it substitutes access to national courts. When I say that there is a substitution of access to national courts, what I mean is, well, from a very Europe-centric perspective, I'm always thinking of the European Convention on Human Rights. So Article 6, paragraph 1 guarantees right to a fair trial, and it is established in practice that basically an agreement to arbitrate is a waiver of right to access to court. Now, at the same time, it's interesting to see whether the states need to guarantee access to any justice. So that's exactly the topic that I'm dealing with in my monograph. So the question that I'm trying to respond to, and some jurisdictions will say, will answer positively, some of them will disagree, is whether there is an implicit obligation of a state to invalidate such a waiver when the impecunious party is without a forum for its claim. So what happens if the claimant cannot afford arbitration? Can they go back to national courts? And of course, national courts are divided on the issue because we don't have a straightforward answer, because we do not regulate arbitration agreement to that extent. There are jurisdictions where national courts were ready to invoke the rights under Article 6, paragraph 1 of the European Convention as an underlying reason to basically disregard the arbitration agreement in cases where the claimant is impecunious. At the same time, we have national courts that adopted so-called approach, go home and cry, because you're a commercial party who concluded this agreement, and it doesn't matter if you had no expectation that you will be impecunious at this point in time, you are bound with this arbitration agreement, which means you cannot go to a national court. And what these national courts are particularly concerned with is, of course, the right of respondent. I'm saying respondent, but the rights of the other party in the dispute, which is usually the respondent, because that party had no expectation that they will end up before a competent national court. So they are emphasizing the need to enforce the will of the parties at the moment of the conclusion of the arbitration agreement. Germany is probably the biggest advocate for the invalidation of the arbitration agreement. In these particular cases, they have changed the ground on which they're allowing this, from unilateral termination for great cause to arbitration agreement as being incapable of being performed. At the same time, France is the biggest advocate for leaving the arbitration agreement in force and valid, even in cases where there is an impecunious party that does not have any access to justice. Interestingly, France has stated that it is up to arbitral tribunal, the arbitrators in the case, to provide justice now, or access to justice. Now, you remember from the beginning that it's quite clear that arbitrators do not provide service of resolving the dispute without being paid in advance. So to what extent is France expecting them to provide access to justice? And they say famously that if there is any violation of that duty, the court will intervene ex post. It's not quite clear at which stage, because if arbitrators do not provide the service, there will be no decision, which means that the parties are not going to be able to challenge that decision in any case. So it's quite, well, the approach is quite clear. It's pacta sunt servanda. It is questionable some other things that French courts have said. So we can conclude that those decisions that allow parties to disregard the arbitration agreement are protecting not access to courts as providers of justice, but access to justice as such. Whereas, on the other hand, decisions enforcing the arbitration agreement are basically emphasizing the parties' free will and choice made at including the financial ones, because when the parties are concluding the arbitration agreement, they should be aware of the financial obligations they will have as well. And again, they also state that arbitrators should guarantee access to justice, which is quite a peculiar statement to make, but maybe one that we should discuss in a different forum. And this brings up certain issues, of course, some of them that I've already mentioned. So the question of court's discretion to basically decide on non-performability of an arbitration agreement, or what if we allow the party to terminate the arbitration agreement and then they stop being impecunious? Should we suspend the arbitration agreement? Does that make sense? Is that a possible solution? Does that mean that the parties need to change forums? What about the interests of the other innocent party? As I said, respondent in most cases that concluded the arbitration agreement, and they're happy to, and they have not expected that they would end up at the competent national court. Should arbitrators be obliged to provide access to arbitral justice? How are national courts to check it? Should we think about legal aid beyond third-party funding and so on in arbitration? So I hope I depicted multiple questions that are asked in practice when it comes to this issue. And that leads to the final topic of today. So after we have gone through the stages of determination and payment, after we have dealt with the questions of how we determine advance on cost, who is to pay it, what happens if it's not paid, whether the party can seek reimbursement immediately if they pay for both, for their opponent as well, what happens if one cannot afford the costs, and so on and so on. So we now have the final question, which is basically what happens once we have the whole proceedings done, and we have the final award, and we ask ourselves, how are the costs to be allocated in that final award among the parties? So we are talking about who should finally bear the costs that are determined in the advance on costs at the beginning of the proceedings. So in litigation, this, again, quite not simple question, but it boils down to two main approaches in civil law and common law countries. Procedural laws for national courts will usually instruct the courts either to apply costs follow the event rule or loser pays it all in some countries that are seeing costs as a possibility to sanction the losing party as well. And we have a so-called American rule mainly applied in common law countries that states that each party will bear its own costs, which means 50-50 when it comes to the advance on costs, as we said at the beginning. I'm going to make it very short. American rule is not applicable in international commercial arbitration for different reasons: cultural, traditional, legislative, regulatory. International commercial arbitration falls on the side of the loser pays it all or costs follow the event rule. American rule is very rarely applied. However, it is important to remember that the arbitrators have full discretion in terms of which costs are to be recoverable and how are they going to be allocated. So when we talk about costs follow the event rule, we have two main questions that we need to deal with. One question is, what is the event? So authors that, and I'm included, I agree with what people have said before me. They have created this notion of moderated costs follow the event rule, which means that each arbitrator or arbitral tribunal can define what the event is. There is no strict rule in institutional arbitration rules or in national acts what is the event that the cost should should follow. So so-called loser pays it all is rarely applied, and it is probably seen only in some cases in domestic arbitration. So when we think about what is the event, there are a few factors that are usually taken into account. The first factor is who is the winner. One would think it's an easy question. It's not. 100% of success, not that often seen in arbitration. So if someone won 80% and of their claim, or 50%, are they still the winner? Is that the event that the cost should follow? Is that the party that should be reimbursed? If there is a claim and a counterclaim, and each party is successful to some extent, how do we then assess who is the winner? So it's a quite an interesting deliberation that arbitral tribunals have at the end. What they also look at is the success of procedural requests made by the parties and procedural conduct in general. Again, this is the sanction, perceived sanction for the parties. As I said, I don't think it's that effective because it comes at the end, and unless it's clearly communicated throughout the process that you will be sanctioned by paying the cost for unnecessary procedural requests, then it doesn't have actually any psychological impact. Necessity of the cost, again, ties into the procedural requests and to what extent certain costs, even for proving, even for evidence production, were necessary. Parties' contribution to the adoption of a pathological clause is quite interesting. So in those cases where the clause is concluded to be pathological, how do we allocate the costs if both parties had equal standing when they were negotiating? Commencement of arbitration proceedings in good faith, again, goes along avoiding unnecessary claims and unnecessary costs. And then finally, arbitrators are applying so-called reasonableness and proportionality tests, which is the widest discretion that they can take into account. And in that sense, they can take, they have wide discretion and not necessarily need to provide explanation for the allocation. So in my work, I usually advocate for clear communication between the arbitrators and the parties as to how they are going to assess the costs. I am not advocating against the discretion. I am advocating for clear communication. Because what happens is that at the end, we could actually prevent, to some extent, time and cost management issues by informing the parties how this is going to be weighted in. It is also important for the arbitrators, if they have parties from different legal families, to communicate, for example, that they will not apply the American rule, or that they will apply it. In that case, also that can have a significant effect on the parties' conduct during the proceedings. One more interesting question I deal with, but I still don't have an answer to, is to what extent can the parties determine the substantive standard under which the arbitrators are to allocate the costs? Because I consider, it's my claim, that this is a substantive decision. So they're following a certain substantive rule, which is either based on their discretion or whether parties can choose in advance the method under which they are to determine the allocation. And then the very final question of today's lecture is, because of the discretion that is at arbitrators' disposal, we have to think about which costs can be allocated. So I talked about procedural costs and party costs. Usually they are covered by institutional rules. Party costs are particularly interesting when one is using contingency fees. To what extent such a fee will be reimbursable? I think the general stance in international commercial arbitration, although you might find some jurisdictions who are much more conservative on that point, is that the reasonable part of the contingency fee or success fee, outcome-based fee, will be reimbursable. There is also an important consideration for the parties to raise in advance whether in-house counsel's fees or basically quantifiable fees based on the time that they will spend on the case will be reimbursable, something that I would advocate for as well. But it is a party costs open some discussion on that as well. And then, of course, third-party funder costs. And in this case, I'm talking about the fee that was paid to the funder itself, themselves, especially if the third-party funder was funding the successful party in the proceedings. And I think we have heard of the case, English case, Esser, that decided basically that that particular fee is reimbursable, recoverable, and can be allocated. A sole arbitrator has decided, and then the whole arbitration community rioted because it's considered against public policy in civil law countries, especially when it comes to contingency fees and so on. However, what they forgot is that in international commercial arbitration, arbitrators do have a full discretion to decide what is to be allocated and in what way. So the English court confirmed the sole arbitrator's decision. And as it stands now, I think it's time to discuss in regulatory terms whether third-party funder costs, especially the fees and contingency fees, are to be recoverable in more specific terms. So that's all from me today. I hope you didn't fall asleep, and I hope we still have some people who are present. I hope my main idea was to show how deeply we need to think about some of these questions, because despite costs being considered to be a rather practical procedural matter, they can cost time and funnily enough, more costs for the parties in international commercial arbitration. I'm happy to answer any questions.
Thank you, Dr. Zivkovic. Thank you so much. That transition from theoretical to practical aspect was pretty interesting. Just a quick thing before I start taking up questions. I quite liked the whole idea when you said with respect to you touched upon the aspect of in-house counsel and their reimbursements, because that again has a very jurisprudential aspect in different jurisdictions where in-house counsel are considered as advocates external to the organization. They don't get paid, but then when you look at Netherlands, etc., you see that they are they are external, in Germany for that matter. And that's when this difference comes. I mean, it's very interesting to note because not many people talk about it. So thank you for touching that up. Let me just start with the questions. I'd be moderating the questions. The bulk of the questions which we are receiving right now pertain to enforcement of security for cost orders, where everybody has been asking, how do you enforce it? Because in my limited understanding, when you look at security for cost orders, etc., it's essentially takes you to a larger question of the police pass of the arbitral tribunal, and do you then go to the courts, or how do you have recourse to a party not following the security for cost order?
Is this, just to clarify, is this the question of whether it's an interim measure or because it depends how we qualify basically the decision on security for costs. So if it is considered to be an interim measure, then it will fall on each and every jurisdiction and their enforcement system, how they are going to deal with it. If we qualify it as something different, for example, if it's considered to be I'm sorry, if it's considered to be a judgment or a judgment-like decision rendered by arbitrators, then it's going to be a different system. So which one is it being asked?
Unfortunately, the common stream seems to be in terms of an interim measure, as a security for cost has been granted by the tribunal.
Oh, yes. Then in that particular, yeah, I see the comment. In that particular case, it depends basically on every jurisdiction. Interim measures are, again, a great topic to write a monograph on and to consolidate the treatment of the enforcement of such interim measures because of their preliminary nature. It's quite difficult to predict. It will definitely not fall, or in majority of cases, it will not fall under the New York Convention system, as far as I know, but that's not one of the topics I'm dealing with. So I dealt with it in very minor terms when I wrote about third-party funders and security for costs and how does one respond to each other. So if a party gets third-party funding and the other side raises the request for security for costs, so that's quite an interesting question, but I don't have really. So if one of the parties opts for third-party funding, the whole question was in the past decade whether it should be disclosed or not. Because of course the third-party funder might bind the funded party not to disclose the matter. However, then we moved towards more transparency, and the question was whether the third-party funder becomes a party to the dispute and so on. Not that we reached a positive response in that. So it's, if we are talking about the stage of arbitration agreement, that's not the stage when we are thinking about third-party funders. That's the moment when the parties think everything will go well and smoothly, and we just need to conclude this great deal and we will have no disputes. The problem arises when one needs to commence the arbitration, and it's usually claimant who opts for third-party funding. And then the question is, of course, whether they need to disclose, mainly because of the conflict of interest discussions that might involve certain arbitrators and so on. But other than that, the whole discussion is very similar to contingency fees, because the whole arrangement is not visible to the other party. So the question is to what extent it's reasonable for the other party who did not maybe even know that the claimant opted for third-party funding to actually reimburse for those costs. So that's what the discussion is all about. It's not if the other party would be more involved, then probably the whole discussion would be much easier, but they're not. So that's why in my work I compare it to contingency fees, because the main problem civil law lawyers had about contingency fees and outcome-based fees is that it does not involve the other party. So basically one of the parties with their counsel, they negotiate a deal, and the question is, why should they reimburse something that they didn't expect to be paid in the first place?
Yeah, I mean, in fact, taking a cue from your point, it's now in terms of disclosure specifically, it's now not restricted to disclosing the existence of funding, but there have been certain instances, say for instance, if I'm not wrong, in probably RSM versus St. Lucia, where they had even asked about the disclosure of the terms of funding, which then, takes a very different realm altogether, because the moment that doesn't happen, the opposite party, of course, because of natural justice and principles of fairness, kind of goes on to be treated on a lesser footing than the funded party, and then they come up with all sorts of claims, which includes security for costs in the first place, and then there are a lot of hearings which are involved in that, and that's another thing which I would run. That's another connection. I mean, this how sequentially you have been speaking about all of those. That's another question which Gautam had. How is a party's conduct during the arbitral proceeding, affect its entitlement to recover costs?
Yes, that's something I mentioned at the end. So in principle, that actually gained more and more importance in the past decade when we started talking about time and cost efficiency of arbitration proceedings. So some authors, arbitrators, institutions opted for cost allocation as a potential sanction for the parties, thinking that if we threaten them with a certain allocation of costs at the end due to their procedural inefficiency or raising unnecessary requests, claims, and so on, claiming unnecessary costs, that they will behave better, sort of, to speak. I see two problems with that. One is costs are in no way taking that much deliberations in the sessions in arbitration, and it's not clearly communicated to the parties for it to work. And the second one is, as I said, if we have a clear winner in the case, yes, of course we can sanction that party because they will expect to reimburse the cost. However, in those cases where let's say the party who had procedural misconduct in that sense is also the losing party, it's very difficult to sanction them more than that, which is usually the case that dilatory tactics are used by most likely losing party. So I think it was more a great idea than a practical solution, although psychologically, yes, there is some value if it's communicated properly.
Just before taking other questions, I just had while you were saying this, I just had a quick thing in my head. So say, for instance, if I just forget conduct on for the time being, how justified do you think it is on the part of the arbitrators to award costs as a penalty to the losing party? Because I mean, I could be wrong here, but the other way of looking at imposition of costs on the losing party is unfair treatment, in my opinion, because somebody filed a claim. They paid the costs for filing the claim. They paid the arbitrators. Now the other person who defended the claim, they paid their part in terms of defending the claim which was imposed upon them. Now, how unfair or fair, in your opinion, is to impose a cost further, that okay, you have defended your claim, you incurred costs for that. The other party who filed the claim incurred costs on that. Now, since you've lost, and of course, as you said, there's no winning or losing here, then how do you how justified is it to ask the other party now to pay up for the entire cost? It could be, if we had 5 issues or 5 claims, 3 could have been 3 could have gone in favor of the claimant and 2 in favor of the defendant. So and even if it's a clear win and loss situation, or probably if the claim was abandoned or something like that, so can the respondent not claim for costs if the claim was abandoned, because then he also paid some amount to defend the claim?
Mm-hmm. Yeah, that's a possibility as well. So just to understand, to see if I understood your question, you're questioning costs follow the event principle in general terms, and speaking in favor of each party pays its own costs.
Yes, that's what my point is, because I find it to be completely unfair. I mean, for both the parties, if I may say so.
May I ask, what is the rule in your jurisdiction, whichever jurisdiction you consider your jurisdiction?
That's what has been happening practically, that costs are being imposed, and that's where we kind of are lacking, because our legislation does not require any sort of a cost or a security for cost. I mean, Of course, the tribunal inherently has been recognized to have the power to, under the legislation, to impose costs on the parties. But then it's not as specific as, if you may say so, the recent English Arbitration Act amendments, wherein they have, specifically made security for cost orders and then other cost-related aspects, they have incorporated that. So that's where my concern comes from, because the tribunal has been given the power. They have their power, but then how judiciously or how justified would it be if they go on to impose it on the losing party and say, okay, since you have lost, you're supposed to pay this as well?
Now that I'm just asking because we are so highly influenced by our own legal tradition, and that's something when you go into the international commercial arbitration, I always find fascinating how easy we just kind of borrow those, just bring everything with us like a baggage of procedural rules. And so I think the answer lies, like, it's a very, I don't want to say cruel, but it is to some extent unfair principle, and I understand where your concern comes from. How it was developed is not based on what happens in the proceedings, but what is considered is that the losing party in the first place, with their behavior, made the proceedings necessary. So if we talk about specific performance and they have not performed, and the other party needed to commence the proceedings, pay the costs, go through the whole dispute, that is what they're being sort of
Penalized for?
Sanctioned for. So it's the behavior that led to the proceedings. So if you, by your contractual misconduct or your breaches, lead to the point where we need to have a dispute, it was considered fair that you will cover the costs of the whole dispute, because and now that's a case when we have a clear winner in the dispute. But then there is not always a clear winner. And in most cases, it's not going to be 100% allocation of costs. It's going to be somewhere in the middle, taking everything into account, success on substantive claims and procedural conduct. But the underlying idea of the cost follow the event principle is that the party brought the dispute with their own behavior, and that's why they should bear the cost of it, if proven. If that answers your question.
Yeah, that does. I mean, but that leads me to another question, which, of course, that will be my last question. Then I'll take up other questions in the chat box. But what happens? How do you think it's justified that, I mean, in subsequent challenges to the award, it may be specifically with respect to the cost, or if the court goes on to find, because the courts don't have access to the merits of the matter, if the courts go on to just turn it over and then put it back on this thing. So how do you see that happening? Because then it just becomes a game of badminton. It's a shuttle or tennis. I mean, the ball's being kicked between two different courts. Comes here, goes there. Comes here, goes there. There's no end to it. There's no settlement to it.
Do you mean if that decision is challenged? Is that what you're referring?
Yeah, that decision is challenged. I mean, maybe the entirety of the award, or maybe only the cost-related aspect of it.
Well, that's another question, because that's something that is not resolved in practice and in theory. But as I mentioned, I am of the opinion that arbitrator's decision on costs, allocation of costs, is of substantive matter.
Yes.
Which means it should not be able to challenge it under the New York Convention or in setting aside proceedings. So that's something that the court should probably not touch, which doesn't mean that they won't. And they might see it as a purely procedural question. But in my mind, this is a clear substantive, this is exercise of substantive decision making. If they do even question it, it should be on the basis of public policy. So in that case, when it is so unreasonable, the allocation that the arbitrators imposed, I would see a potential for challenging it. So it should not go back and forth. That's what I'm trying to say.
I get the point. But the moment you say public policy, I'm reminded of Professor Vasek.
Yes, I know. He would probably have
You'll be a
another
better-
hour and a half long presentation on that.
Exactly. But there's this interesting question I have received from Kulus. She says, what role do external factors such as market trends and geopolitical events and advancement in technology play in shaping the cost aspects, and how can parties stay abreast with this development in terms of cost management strategies? Now, that's very interesting. In terms of cost management strategies.
Yeah, that's a great question. When the COVID hit, I think we all, we needed to shift to the online options. And I did speak on the topic of arbitration and technology. And one would expect, yes, that would be basically the solution. However, I don't think the change is so fast. After the COVID, I think majority of hearings have returned to be in person, and I think that question does not have you don't need a legal mind to answer it. It's more a question of psychology. And one thing in particular that I'm dealing with when it comes to technology, of course, and there are other points mentioned there, but when it comes to technology, one point that I am very interested in is to what extent the communication works the way we communicate now, and to what extent, for example, disability can be overcome in online hearings and so on and so forth. Not to mention, of course, digital literacy of arbitrators and councils and so on. So yes, it's a good idea. I think it is the future. It does impact, especially with COVID, we were pushed to make some changes. But it wasn't as fast, and it's not going to be fast, no matter how much we want to believe that. So that would be my very vague answer to the question, but a great point.
Another interesting one is of course fairly controversial, but Nehal asks as to how can one create a transnational model of cost allocation where there's limited differences with respect to jurisdictions. Now that also takes us to how security for costs and other cost allocation aspects are treated in civil law and common law jurisdictions. So how do you see it? Do you see a universal code sometime in the future?
I think it's already there, but let me put a disclaimer. So I am a transnational lawyer, and my perspective or my stance on arbitration is that we are working in a transnational arbitral legal order. In a sense, whenever we have, which means that every time we have discretion on the tribunal side, they are actually free to create their own substantive rules. And those rules, as long as they are transferred from one tribunal to another, will become a new substantive norm. I'm not talking about precedents. That's not what transnational legal theory is. I'm talking about the fact that discretion allows to go beyond national and international orders. So for me, when we look at the practice, we see that there is a moderated cost follow the event that is prevailing principle applied by the arbitral tribunal. And for me, that's a transnational norm. However, there are different theories of arbitration, such as national or also territorial so-called theory that ties arbitration to the jurisdiction in which it's seated, international due to New York Convention. So I know that my opinion is based on my, let's call it philosophy or theory of arbitration. So that's how I see that we can overcome this. And I think we do. I think the practice is showing it. Now,
to a large extent. To a large extent.
Yeah.
Thank you. That's interesting because, the whole idea of it being associated to the seat and then things being decided accordingly, specifically the way it happens in England, it's kind of an approach, but it needs to be widely accepted. I don't know how would it pan out. I don't know whether I'm right or wrong in saying this, but how would it pan out in delocalized jurisdictions where you follow delocalization? And that's...
Yes, I mean, it's for my students, I always give the example of France, which is
Same
the
here.
only jurisdiction that is a textbook example of
Of delocalization.
delocalized theory. So yes, you can have those jurisdictions coexisting with a more international or national localized theories. I don't think the English jurisdiction is that territorial. They do allow, I think one of the most territorial would probably be the United States
I just
when
didn't
it
want to
comes
name
to
it.
arbitration. Yeah.
Over Americanization, suffering.
Yeah.
Yeah. Let's just move on to the next question then. Okay, then there's this again something with respect to impecuniosity. What sort of an evidence is required to prove impecuniosity as opposed to bankruptcy, which can be proven fairly easily? What do you say, Professor?
I'd say I had that question. I was investigating that question. I'm not writing about it, but I was wondering as well. I think it's mainly the point of proving the to what extent you have liquid assets and so on. So financial statements, and there is no rule. I asked arbitrators, I asked counsels, what would they do? What did they do? It's usually a matter of what the national court will accept in that particular case, which is usually financial statements. Yeah, I don't have a better, again, a great question.
It is.
Yeah.
In fact, I mean, if you come to think of it, insolvency, there are situations where mere initiation of insolvency proceedings in A jurisdiction or B jurisdiction has been taken to be some sort of a handicap on the part of the party against which it has happened, because it's not always in multinational cases. You may have an organ of the organization operating in one jurisdiction, and it's that particular organ which is facing or against which an insolvency proceeding has been initiated. And then in my experience, of course, there have been situations where the defendants have come running, or the claimants have come running, I mean, either parties, they've come running saying that, oh, this particular organ or this particular joint venture in B jurisdiction has been facing this, and I seated in C jurisdiction would kind of go ahead and initiate and probably file a security for cause claim, or say whatever that may be. That's very interesting. But yes, I agree with you. There's nothing standard. I mean, there's no standard per se which kind of takes you to have to having a uniform practice of, okay, this is the benchmark from which I would probably start identifying. Yeah. Great question. Then I think this would be the last question. It says, in an instance where the parties to an international arbitration operate in different economies, transact with different currencies, different financial capacities, what will be the best metric for determining arbitration costs that will not be deemed outrageous for the party which is, with a lower financial capacity and a weaker economic currency? Thus, there is the metric. Is there a metric that considers each party's prevailing peculiar financial economic circumstances?
Again, I'm so happy to see these questions, because this is exactly what I want to spark, even if I don't have an answer. That's a fantastic question. Now, there is this, it can be answered from the perspective of international commercial arbitration, and it's quite straightforward. It's a brutal approach. You agree to arbitrate under certain set of rules. You agree to the cost schedule. And as I said, if it proves to be that you are impecunious at the moment of dispute, you cannot, in some jurisdictions, you cannot invoke it to terminate the agreement. In some jurisdictions, you can do exactly that.
Yeah.
However, when we step outside of the international commercial arbitration, and I have dealt with one particular topic, and this is very much jurisdiction specific, which involves franchise agreements. And it was quite interesting. Again, Germany is very much, human rights sensitive and access to justice sensitive type of jurisdiction. Even though franchise agreements are considered to be commercial in their nature, because of this imbalance between the parties, so we have a big party providing the franchise, and then we have little parties, weaker parties, who are taking it over. German courts have come to a conclusion that it is to be treated as consumer arbitration.
Mhm.
And then that pulls a completely different set of regulation and laws.
Yeah, it does.
So in these cases, I can't think of any other example but that it would be worth a while to claim that it's basically a consumer contract, or that it behaves like a consumer contract. And if it behaves like one, it is one. So I can imagine that in some cases, not only in franchise agreements, which were treated as commercial contracts, one can actually invoke the consumer legal framework to apply. That would be quite an interesting. Again, I don't know of any other example. If it's a purely commercial contract, the initial thought will be you agree to it, you have to perform according to it, but there is some space in some jurisdictions to step outside of the commercial framework.
Agreed. How do you, but in a question like this, do you not see the possibility of third-party funding in its purest form coming out as an access to justice tool? Could be. I mean,
well, it depends how we frame access to justice, because I have this. It's not a solution in my opinion, because of due diligence process. So the percentage of success that third-party funders are aiming at is so high that I do not even consider it as legal aid to that extent.
because that's how it has been sold off to the entire world, that third-party funding is an access to justice. It's a tool for access to justice. So when it comes to representation of unequal parties, somebody told me, can't name them, but somebody told me that why can't we have this? Because third-party funding is necessary, because your unequal parties are pitted against each other in one jurisdiction. And then of course it comes from the same question that different economic situations, difference in currencies, etc., and the amount of claim is really very high. So why don't you go for a funder so as to have access to justice, quote unquote? But that's just a marketing gimmick, I think.
Absolutely. Yes, I would agree. That's what happens when the industry discusses theoretical aspects. And I do have my personal and professional issues with that, but in no way do I see third-party funding as a response to access to justice, guaranteeing access to justice in arbitration.
Agreed. I mean, it also depends on the structure of funding, because you have been constantly harping on the conditional fee, the success fee aspect of it. But when you break it down, it might also be a donation, as happened in the Philip Morris situation, and then it could be a joint venture, it could be anything. That insurance, for that matter, after the event and before the event insurances. So that structure also makes some difference. But I think that this whole idea of access to justice and third-party funding and then helping out costs is slightly gray, to be very safe in saying it.
Diplomatic.
Yeah, agreed.
Yes.
Agreed. So I don't think we have more questions, but I think we have answered all questions, and I really want to thank you, Dr. Zivkovic, for taking out your time and specifically, telling us more about that there's much more to cost than quote unquote security for costs. There's much more to it, and really it was good to hear your thoughts on that.
Thank you so much for the invitation and giving me this forum. This is probably the best talk I have given in my career because all the questions that I received, and thank you for giving me the forum to talk about something that I'm so passionate about. So this was quite a big pleasure for me. So thank you for that.
Thank you so much, Dr. Zivkovic. Have a great evening.
Thank you. You too.
Thank you. Pleasure.